Okay, hello, welcome. Finbar. Well, first, Professor Finbar and Company, thank you for organizing this. I hope you all had a good and productive Golden Week, that you used it to read, to further your education, to enlighten yourself. We continue our enlightenment program by having Professor Suzuki. As you know, we've had a program on Japanese healthcare, or healthy debate series, and so we've reached the end of healthcare, in other words, end of life decision making. We have no plan to go beyond and have studies on the market for funeral homes in Japan, but this will be a logical conclusion for the business school. So I'm extremely happy with Professor Suzuki. You came to hear her and not me, so the floor is yours. And after presentations, we'll have our usual question and answer session. So thank you again, Professor Suzuki.
Thank you for welcoming me here this afternoon to Temple University. Oh, thank you. I'm really thrilled to be here. I have been in Japan for 5 weeks, and sadly I leave this weekend. And despite the earthquake and the tsunami and the problems with the nuclear reactor, I found this community to be so welcoming and so warm. I really appreciate the time that I've had here. I'd like to thank the faculty at Temple University, especially the Institute of Contemporary Asian Studies Director Robert Jadurek, and also Professor Finbar McCarthy at the Law School. Today, I will discuss my research on how culture, a set of beliefs shared by a group of people, affects the process of planning and decision-making regarding end-of-life issues. I think it might be helpful for me to tell you a little bit about my background so you'll know how I arrived at researching this particular issue. I'm currently a law professor at the University of New Mexico School of Law. I am on sabbatical this semester, but begin to teach in the clinical law program next week. I teach a seminar on bioethics, where students explore topics including healthcare reform, healthcare decision-making, the right to die, assisted suicide, and euthanasia. We also discuss non-standard reproduction and reproductive rights, potential fetal-maternal conflict, the Human Genome Project and use of genetic information, research involving human subjects, and ethics committees. I also teach a class, as a seminar on acquired immune deficiency syndrome, AIDS, and the law. And as I said, I teach in the clinical law program. In the clinical law program, I work with second and third year law students, and we represent individuals to address their needs, both civil and criminal. The areas that the students work in include family law, domestic violence and divorce, public benefits, housing, access to health care, and juvenile delinquency. Students have assisted clients in the law clinic who have wanted last wills and testaments completed, or who have wanted to complete advanced directives for health care. The services that the students provide is most often free for the clients, although sometimes we do charge a minimal amount for either a case intake fee or a client's acceptance fee. The students learn substantive law, oral and written advocacy, trial practice, professional responsibility, evidence, and they learn how to be lawyers while under the supervision of a supervising professor of such name. Issues of social justice, poverty, culture, race, and gender are pervasive in the cases that the students work on in the clinic. The clinical law program at the University of New Mexico is a required course for graduation. The student and the client population in New Mexico is diverse. It includes Caucasians, American Indians, few Asians, African Americans, Hispanics. Upon graduation from law school, the students are able to sit for a bar in a jurisdiction of their choice. I've held a previous position as a public interest lawyer in New York, serving communities affected by HIV/AIDS, most often helping parents to plan for who would be their children's guardians if the parents were not available to take care of the children. So medical care is advanced to the extent that it can help patients to live longer, but not necessarily better. Quantity of life, meaning the prolonging of life, can conflict with the quality of life of a patient who is facing his or her mortality. In the United States, dying can be very expensive. Dying in the hospital, as opposed to at home or under hospice care, is very common, even for people who have been suffering from a progressive terminal illness or condition. The United States national average for medical spending in the final year of care is $25,000. These costs are often covered by the American public, as 80% of the people who die in the United States receive Medicare, which is a federal finance government insurance program. Advanced planning treatment became a topic of controversy during the 2009 healthcare reform debate, sensationalized in the media as death panels. Some critics declare that under the healthcare reform laws, there is a proposal that decisions would be made to ration or limit health care to patients who are considered unproductive to society. So the disabled, those who were terminally ill, and those who are elderly. And those decisions would be made by government bureaucrats. The cost savings measure, which was allegedly created by Democrats, would require that every 5 years, patients receiving Medicare insurance would undergo a counseling session that would tell them how to end their life sooner. There was a determination that the death panels would save up to $2.7 billion over 10 years. In reality, there were really no death panels in the healthcare reform legislation. The House of Representatives version of the bill provided that Medicare reimbursement would be given for an optional consultation between the patient and the provider regarding advanced care planning. It would have allowed the practitioner to explain advanced directives such as living wills and durable powers of attorney, healthcare proxies, palliative care and hospice, and physicians' orders regarding life-sustaining treatment. I will discuss some of these plans in a few minutes, but briefly, these discussions by a practitioner with a patient who is competent to make these decisions would focus on how to promote patient autonomy and appropriate medical treatment when the patient was not competent to make any decisions for health care. So the House version of healthcare reform did not advance before Congress, and the so-called death panels measures not incorporated into the Affordable Care Act that was enacted and that is under attack under the current Congress and also by some states. So in general, since there are no death panels, no Medicare reimbursement for these types of discussions, these discussions aren't happening. And right now, physicians in the United States can't really afford to have discussions with patients. There's no one paying for those discussions. So patients and doctors face a continuing problem that at the point where vital decisions need to be made regarding medical treatment, the patient's not capable of stating his or her wishes due to incompetency or incapacity, and the patient has not set forth his desires or her desires for health care. So the doctor may need to talk to family members to try to determine what type of treatment a patient would want. And the family members may have had those discussions with the patient, or they might not have. And also the family members, although they might have had these discussions with the patient, might not have had specific discussions in regard to the type of condition that the patient is currently in. So this can cause some problems for the doctors, the families, and of course the patient. Nearly every state has some form of advanced legislation, advanced directive legislation, providing a mechanism for a person to set forth in advance of an emergency situation directions for what type of health care the person wants, or who should make those decisions in the event the individual is not able to due to incompetency or incapacity. Many types of advanced planning is related to medical treatment and is regulated by state statute. The terminology might be confusing because some states vary in the terminology and the definitions of what is available in that particular state. An advance directive may be a living will. That's a document that a person will execute while competent, stating what types of treatment he or she would want or would want withheld. And also, an advance directive can be a power of attorney or a healthcare proxy. The power of attorney can be combined with a living will, depending on the jurisdiction, whether the jurisdiction allows a living will or the healthcare proxy. So the patient, while competent, can complete the advance directive known as the power of attorney or the healthcare proxy, and can appoint another individual as the surrogate to make decisions to consent to treatment, or can make decisions in regard to withholding treatment at a time that the patient were unable to express his or her desires. A do not resuscitate order, or DNR, is a directive by a patient that resuscitation should not be given if a patient suffers from cardiac or respiratory arrest. So this type of treatment would include CPR, cardiopulmonary resuscitation, and intubation. The enforceability of any of these directives would be regulated by state statute. In the absence of any written directive, a state might allow by statute for an adult relative or even a non-relative to render treatment decisions for a patient who was incapacitated. So there are benefits to a patient who contemplates and decides, while having capacity to make decisions, what treatment he would want administered or what treatment he or she would want withheld. Patient autonomy is supported as is rational, informed decision-making divorced from a critical time in a patient's health care treatment process when immediate, literal life or death decisions need to be made. The benefits of end-of-life consultations with the patient includes better pain relief, appropriate placement at hospice care at home or hospice facilities, prevention of medical utility disputes, which are disputes between generally the surrogate, family member, and the provider whether or not to continue treatment, litigation of avoidance, and more opportunity for patients to work on issues of life closure. The existence of a written healthcare proxy is positively indicative of higher patient satisfaction with comfort care for the patient. So there are limitations, however, to advance directives. Situations may arise which conflict with patient care and, situations which arise that can cause conflict include where a patient has selected more than one healthcare proxy and stated the desire that the proxies agree on a treatment to be given to a patient, where a patient by the directive or healthcare proxy desires the cessation of treatment, but the doctor, for professional and ethical reasons, wants to continue care. Many of you are familiar with the Hippocratic Oath, do no harm. And there are times when the doctor wants to continue treatment and does not wish to follow an advance directive written by a patient. Sometimes a directive may be too vague and not give adequate direction to a doctor, or sometimes a directive is so specific it doesn't actually speak to the condition in which the patient is at that time. So let's turn to looking at cultural issues in medical treatment and end-of-life planning. Social science research provides evidence that culture influences medical treatment in a number of ways. Research suggests that a healthcare provider's diagnostic and treatment decisions, as well as feelings about a patient, are influenced by the patient's race and ethnicity. Several studies have shown that racial concordance, or the sharing of the same race between the patient and the provider, is substantially and positively related to patient satisfaction, although it is not essential for patient satisfaction. Most people find it difficult in informal discussion, and most providers find it very difficult in their formal discussions with patients to to discuss end-of-life decision-making. Some doctors will make other medical staff have those discussions with patients, even those doctors who really appreciate the benefits of patient autonomy. End-of-life consultation is beneficial under normative Western medical practices, and it can be challenging when those practices are applied to patients who possess divergent cultural values. You can imagine the varied perspectives on death that are informed by a patient's cultural affiliation. A culture may prefer that decisions in regard to end-of-life decision-making are made as a group or as a family, and that can affect patient autonomy. Social scientists have researched the effects of a person's culture on the process of making advanced plans for healthcare, the results of which are helpful to lawyers in their work. These studies may seem essentialist, and they render conclusions that might appear to be generalizations of what is actually a diverse group of people. Those of you familiar with social science research are aware of the essentialist nature of some studies. Although Japanese society may be more homogeneous than American society, I certainly don't intend today to paint Japanese society as a stereotype. However, I do think that social science research can be very informative for purposes of determining how best practices for lawyers working on advanced health directives can be developed. There have been studies focused on the views of Japanese people in Japan and Japanese Americans in the United States regarding advanced healthcare planning. I think you would not be surprised to know that there are traditional Japanese values that shape how Japanese Americans feel on the subject of health and death and dying. And this makes this group of Japanese Americans different from other groups of people in the United States. Other studies have found that some traditional Japanese values regarding medical consent and the disclosing of diagnoses of terminal illness or disease directly to patients is evolving, and more patients in Japan actually now desire more transparency in healthcare. In the United States, a competent individual who is a patient is generally the first person to whom a doctor turns and will disclose the diagnosis of a terminal illness. Advanced planning for healthcare is widely available in the United States, but the form in which the plan is set forth will vary according to the applicable law. Each state has passed laws that set forth what is available for a patient and allows the patient to make treatment decisions in advance, in writing or orally. Almost all states allow by statute the execution of powers of attorney for health care. Each state, however, is able to pass legislation to dictate what's available and enforceable in that jurisdiction. The National Conference of Commissioners of Uniform State Laws is a group of lawyers, law professors, and judges who develop and draft proposed laws that the commissioners believe should be and have potential to be uniform across the states in order to promote justice. One concern of the commissioners is that a person may execute a valid end-of-life form in one state and then move to another state where that form is not valid and not enforceable. A state is allowed to submit a uniform law directly and pass it as law in its legislature, or a state may revise the uniform law and take parts of it for passage as a statute. The National Conference of Commissioners drafted a Uniform Healthcare Decisions Act, approved by the American Bar Association in 1994. The Uniform Healthcare Decisions Act contains provisions for an advanced healthcare directive, including optional form language, appointment of a power of attorney for healthcare, instructions for healthcare, do not resuscitate directions, organ and tissue donation, comfort care administration, even if it will hasten the death of a patient, and designation of a primary physician. Although it is widely available in the United States, the actual execution and use of advanced directives vary. As many as 40 to 75% of U.S. residents might have some form of an advance directive. Anecdotally, though, most clients at the University of New Mexico School of Law do not have forms. So I am actually not sure how accurate the estimation of 40 to 75% of people in the United States is in terms of people who have executed advance directives. A study of Japanese Americans found that most had not had discussions about end-of-life issues with their healthcare providers, but many wished to do so. Overall, the patients preferred that if they were not able to express a treatment preference due to incapacity or incompetency, the providers would speak with family or friends together so that a joint decision could be made. Japanese Americans also expressed a desire not to be burdened on family members. The burden was stated with an emphasis on avoiding being a financial burden on the family due to the high cost of health care in the United States. In the United States, a doctor may object to group decision-making when the patient is competent to make his or her decisions regarding treatment. The doctor may have ethical and professional bases for this objection, as a group decision model can be in tension with the patient's autonomy model. And it can be in conflict with patient confidentiality. As an example, a competent patient may ask that a provider speak with a surrogate, such as the adult son, about healthcare treatment even when there's no directive in writing. The patient's reasoning may be, if the patient's condition were to deteriorate to the extent that the patient were incapacitated and must continue to be cared for by the oldest son and the rest of the family, or if the patient were to die, the family members would suffer greatly from the impact of the healthcare treatment or the death. So the patient may wish that the survivors have some say as to how they would suffer, even if it might be to the detriment of the patient and the patient's self-determination. Or a patient may know that her desired treatment differs from that of her son, and she would prefer to not make her son unhappy. So she allows her oldest son to make decisions regarding her health care. I would like to briefly mention how healthcare planning is viewed in other cultures in the United States. Looking at American Indians, which comprise a significant population in New Mexico, one study of Navajo subjects was conducted to determine the effects of negative information, such as end-of-life issues, and also to investigate the limitations of Western bioethical perspectives on Navajo beliefs. The Navajos have a tradition and a concept of hojo, which combines the concepts of beauty, goodness, order, harmony, all that is positive and ideal. Discussions of end-of-life issues, such as advance directives, was viewed as negative and violative of hojo. So Navajo may refuse to discuss any issues that relate to death, or they may refuse to conduct any advanced planning, including health care treatment planning, and also trust in the state issues. The Catholic religion also influences people in New Mexico, which has many members who are Mexican, of Mexican descent, and are Catholic. Termination of life support may be against a Catholic person's beliefs because it may be considered to be the taking of a human life that was created by God. So the futility disputes that I mentioned earlier do occur with Hispanic families. Physical suffering of the earthly body, however, may show inner strength and faith in the execution of God's plan for the individual. So a patient may not agree to comfort care and relief from pain that might be available to a patient. If end-of-life decisions are made, Mexican Americans overall prefer a family decision-making process. Advanced planning in Japan is distinctly different from that in the United States. And we see that the reasoning is cultural, social, familial, and also legal. Like in the United States, a pattern of legal issues develops as medical science allows people to live longer, but with varying qualities of life. The advancement of science raises many issues that society has not had to face in the past, when treatment options to increase longevity were not available. These matters, along with changing patterns of families, have affected decision-making processes regarding end-of-life issues in Japan. Although a person in Japan may complete an advance directive, it's not legally enforceable, and it's not legally binding on healthcare providers or to family members whose names may be in those advance directives. Perspectives of Japanese people regarding advance directives have been studied, with the results differing from people in the United States. Although many individuals in Japan feel that it's important to express their desires regarding health care in advance of meeting these forms, or meeting these decisions made, fewer have completed written forms than in the United States. Some people have discussed end-of-life issues with their family members and believe that oral directives are adequate evidence of their desires. The study indicated that if an advance directive is written, there's a preference that the directive be written in broad terms rather than in specific instructions. The preference serves to avoid an advance directive conflicting with the expected role of family in decision-making in Japanese society. In studies, reasons that Japanese do not complete advance directives include that family members or doctors will make the appropriate decisions when necessary. Many Japanese have a sense that the individual is not just the sole person, but is interdependent with other people, so that important decisions about oneself that would greatly affect others should not be made by that one person, and in this instance, the patient. The Japanese Ministry of Health, Labor, and Welfare has issued guidelines for the decision process for the terminal care of patients. The guidelines suggest that first, the patient should make the decision about his or her medical care if the patient is alert and competent. Second, if that patient is not able to make decisions for himself or herself, then the next step in the guidelines is to look to the family to make those decisions. Third, if the family is not available, then the medical team consisting of the doctor, the nurse, the medical social worker, anyone in whose care the patient is, would discuss together what decisions need to be made. This step in the guidelines is an acknowledgement that other hospital staff may have spent more time with the patient than the doctor, and then may have also had more of an opportunity to discuss end-of-life medical care decision-making with the patient than the doctor. Documentation of a patient's wishes through an advance directive, even though it's not legally binding in Japan, may be helpful to develop a treatment plan within these guidelines. Perspectives on death and decisions regarding treatment may be influenced by a patient's religion. From a Buddhist perspective, Japanese may see death as a part of life. But this perspective may not necessarily lead to free and open discussion about death and about end-of-life decision-making. Family dynamics and group decision-making should be considered in medical decision-making. In Japan, the number of children per household is shrinking, and this decreases the number of people involved in a family decision. But it's becoming more likely that an elder parent will not be living with an adult child. And perhaps this decrease in the family size results in more of a psychological burden on the sole child, who must make decisions on behalf of one parent. The burden can also be considered in part financial, even in Japan, as the patient would contribute at least a portion of the cost of the health care. Integral to the idea of self-interdependent family members is a person's desire not to be a burden on one's family, which is very strong in Japanese society. But in Japanese society, it's not necessarily expressed as a financial burden as it is among Japanese Americans in the United States. In Japan, almost any discussion on the matter of advanced planning as it reflects patient autonomy will raise the issue of medical paternalism, concept that decisions regarding healthcare are best made by the provider. There's respect for the doctor in both American society and Japanese society, and the idea that doctor knows best survives in both cultures. Traditionally, in Japan, a diagnosis of a terminal condition may have been withheld from a patient by a doctor, who instead would advise the family members of a terminal diagnosis. The family members and the doctor would then discuss whether and how to give this information to the patient. The process could be followed at the request of the family member or the patient. Sometimes the patient will tell the doctor, I don't want to know my diagnosis, so just go ahead and figure out what it is and talk to my family members about how I should be cared for. Recently, however, in Japan, we've seen a trend toward increasing interest by the patient to receive terminal diagnoses directly from the doctor, and of those diagnoses being given to a patient. Actually knowing one's diagnosis can be empowering to a patient and also provide the patient with the information to be able to make to give some direction as to healthcare. So I'd like you to consider every factor that's part of planning for healthcare treatment at the end of an individual's life. There are advantages to early planning and early consideration, what kind of treatment a patient would want withheld or would want given, so that a patient can make decisions regarding his or her treatment early. And so when the care actually needs to be made or given, we know what kind of treatment should be given to a particular patient. An advance directive can help an individual to ensure that his or her wishes are carried out in the event that the patient is unable to communicate her desires. A written advance directive may have some advantages over oral directives to relatives and may be considered more reliable than oral directives and statements in the event of a conflict between the provider and the family member. Although an advance directive can support patient autonomy and self-determination, the reality is that self-independence and family decision-making processes can come in conflict with patient autonomy. So you've heard that advance directives are legally enforceable and available in some form in the United States. But in the United States, end-of-life care has become politicized, interfering with the right to refuse medical treatment and with professional judgment about what constitutes good medical practices, undermining the principles of autonomy and criminalizing palliative care. Advanced planning and self-determination is increasing in practice in Japan. I've shared with you a sample of the issues involved in advanced planning for healthcare. To increase patient awareness of the availability and the value of advanced planning, lawyers and other professionals must consider how this information might be received when speaking with a client or with a patient. We can't stereotype patient reaction to advanced directive counseling based on cultural affiliation, but lawyers, physicians, and other qualified health professionals must be competent to have these discussions and must take into account their client's cultural background when having these discussions with patients. So a lawyer should place a client in context and not stereotype how a client might react based on cultural background. In the legal setting, lawyers who work with any population must also, however, be cognizant of cultural issues surrounding healthcare treatment. In a legal setting, the discussion would most likely occur at a time when there's no emergency and no plan that is required in regard to medical care for the client. If we accept that end-of-life consultations are benefits to clients, then the services provided must consider client characteristics, including all cultures do not share the same beliefs regarding death and dying, and that decision-making processes can be informed by the client's cultural background. So you've heard a bit today about end-of-life decision-making, about differences between Japanese Americans in the United States and the Japanese in Japan. We've talked a bit about healthcare provision in the United States and in Japan. So I'd be happy to answer any questions, and I look forward to fruitful discussion.
Questions?
My name is Sado. I'm a business person. First of all, thank you very much for the wonderful seminar, and your English is quite impressively beautiful.
Oh,
Despite the fact that this is the extremely difficult topic. And so my first question is, what made you decide to get into this very specialized field?
Oh, well, thank you very much for your kind words. My legal training is actually informed by my background before. I was a psychology major in undergraduate studies, and when I decided to go to law school, I knew I wanted to enter a service profession. I wanted to work at a place where I would be helping people who were really underrepresented. So I started working at the Legal Aid Society, and at that time I was working with whoever came in, but everyone was poor. But I focused on people who were living with HIV and AIDS, because that was certainly an underrepresented population, but a growing population in New York City. From there, I moved to the HIV Law Project, where I specifically worked with people who were HIV positive. So I think so much of my legal career has been working with people who are living with a terminal illness, and we're able to talk about it, and make plans for their children. And so, in a way, this issue the topic of death was sort of normalized in my day-to-day work with this group of individuals. And although I no longer work specifically with people who are HIV positive, we do have clients who are HIV positive who come into the clinic. But now I work with, again, just a general poor population. One area where we do intakes is with the pediatrics unit of the hospital. So I do have clients, students see the children and their families, and so there is some medical care that is being provided to the patient and to the family. I think it's just, all this comes together is something that I'm really interested in, that I want to help people. I see that there's a need. It's the population who comes to talk to me, and I feel that I'm able to provide this service. I don't know if that really answers your question, except for it's what I see come into the clinic.
You answered me a lot, but the second, allow me to make the second question, and this is it. You are from United States.
Yes.
Where I see money determines nearly everything. Like the $25,000 for the death.
Mm-hmm.
I was curious about what does it mean. $25,000, which is only 2 million yen, or extremely expensive 2 million yen by Japanese standards.
Right. Okay. It's an app.
Yeah, I know it's obvious, but please explain that. What does it consist?
It's medical care itself.
Yes.
So since it's average, some people will die without receiving a lot of medical care in that last year.
Yeah, but
Other
medical
people will
care
use it.
expenses countable place. So the patients die in the countable places like hospitals, right?
Right, like hospitals,
Okay,
yes.
so traceable death.
Yes.
I presume there are a lot of people who are not dying in the hospital.
That's right. That's how the costs can be actually kept relatively low, right? Because we're talking about medical care. So if all people who died spent their last year in the hospital, the average would be much higher than $25,000.
Okay. Thank you.
Yes.
Peter Smith, I'm a retiree living in Japan. In the U.S., there's a legal framework for legal relatives and identification of boxes, opportunity. So it makes sense to go to a lawyer if that's what you want to do and have these documents drafted. You say in Japan, such advanced planning has no legal basis. It's not legally enforceable.
Right, there's no law which provides a form that a person might fill out that is enforceable. That's right.
Does it make any sense to consult a lawyer in Japan about such issues if there's no law?
If a patient wanted to complete an advance directive, or if a person wants to complete an advance directive in Japan, a person can do so without a lawyer. Just like in the United States, a person can do so without a lawyer.
But in the U.S., you're dealing in state jurisdiction and relative to legal issues, which
That's right.
a lawyer can be helpful in making sure you don't get the document wrong.
That's right. So since there's no uniform form in Japan that's been approved by the government, a person who wanted to complete a form could fill one out, could consult a lawyer, but you're right, the lawyer can't say, well, this will be the form that we can actually use that we know is enforceable in Japan, because there is no enforceable directive. But there actually are forms available. There is one that was recently published, it's a directive along with instructions. And I know that there are forms available online through various organizations in Japan so that people can complete forms. So advanced directives are being created and executed by
But if the doctor
Japanese people.
chooses to ignore it, then you're out of line.
If a doctor chooses to ignore it, there's nothing, it's the patient, let's say it's the patient's family would be able to go to court and say, this is what the patient wanted, it should be followed. However, if we look at the guidelines which have been enacted in Japan, which are just guidelines, right? So they're also not the law.
Because there have been issues in Japan where the families make a decision and the doctor gets sued for murder.
Well, for following the family or for not following the family?
Sometimes in either case.
So I would say I think we have those in the United States as well. But in terms of in Japan, if I've lost my train of thought. If the family has the form, an advance directive that has been written by the patient in Japan, it's not enforceable, so that the family cannot go to court and ask that the court issue an order to enforce this form. However, if you look at the guidelines, first the doctor would talk to the patient's unavailable. Second, the family. Consulting the family says, look, we're looking out for the best interests of our family member, and in fact, the family member has left us some written instructions saying this is what he or she would want. So we're telling you, doctor, since you're following the guidelines, this is what the patient wants. So you're consulting with us, and we're asking you to follow not only these directives, but follow us, because we're following the directive as well.
So creating some sort of document can hurt, might help.
I hope it can't hurt, but yes, it can help. I think that it can be good in terms of evidence to help a doctor who decides to follow the patient's wishes and the family's wishes, right, and follow the guidelines and terminate treatment. So if there isn't a criminal investigation, the doctor certainly has lots of backup.
I do believe there is the legal organ donor form now that has passed, say, within a year or so, which you can carry a donor card now that is legally binding, that does say I would like to donate certain organs, but I believe the family can override that, or perhaps cannot.
I'm not, I actually, I know that there was some recent change in law, and I know it affected the donation of children's organs. I'm not sure about the adults, but to the extent that we have the donor cards in the United States, in some jurisdictions, a person when getting a driver's license can have a little heart sticker put on the driver's license saying, I want to be an organ donor. Those are not enforceable either. If the person that ends up in the hospital and on life support and the family doesn't want the organs donated, they will not be donated. So many people get the sticker placed on thinking, oh, now I'm a donor. It's actually, that's not enforceable in the United States. At least in the jurisdiction in which I practice. Yes?
I am a medical doctor, so I like to state my experience from the front line. I was dealing many dying patients, and the situation was not as you stated under the guideline. The situation is most of the time panicky, because first you said the patient must make the decision. Number one, the patient is in almost all the time in confusion and not in good shape to make decision by himself. Maybe in stupor or in very consciousness was devastated. And the second, the family and doctor. And in many cases, the family members or relative members and doctor team, they are dodging the responsibility from one another. I mean, no one wants to get accused. No one wants to get sued.
Right.
So nowadays doctors are so afraid of being sued. So they follow the opinion of relatives or patient's family. And the patient's family, in many cases, they are also very afraid of being accused of one another. So if one member stated, I want longer life, whatever the condition, then everyone else are forced to follow the opinion. In that case, in my actual experience, the patient in terminal condition of 80 years old, 90 years old are bound to under the recirculation system and are forced to insert the feeding tube and forced to get into the artificial circulation, artificial respiration machine. So it's tragic. So someone must be the opinion leader. So my opinion is the family member must have the ears to listen to the doctor's opinion. And the baseline, I think the most universal guideline is one, do not let the patient suffer. It's a very important thing. And the second is to not let the person be the burden of the others. Let the patient die in certain time, if that must to be.
Thank you for sharing these thoughts, because it's true that right in Japan there are guidelines, so this is not the law. So first the patient, and the guidelines first the patient is consulted. So if the patient is consulted but is in a stupor or is confused, then the doctor's not able to get a decision from this patient. So the next step would be the family members. And in looking at or discussing the issue with all the family members, no one wants to be the one who says, okay, pull the plug, right? This happens in the United States as well. We have fertility disputes which occur. So patient is not going to recover. And usually the fertility dispute is that the surrogate family member wants the care to continue and the doctor actually wants to end the care. We're thinking about the patient suffering. So let's not have the patient suffer any longer. in these cases, when there's a futility dispute, in 90% of the cases where there's a discussion between the provider and the family, within 5 days, the family will decide to follow the doctor's recommendation. But in 10% of the cases, the family wants to continue treatment. So a doctor can go to court, or a family can go to court too, depending on how the dispute is going, to get a court order to be able to terminate treatment. So that does happen in the United States as well, that there are concerns about the patient's suffering. And if the doctor wants to terminate treatment, the family wants to continue treatment, one option can be that the court will order the doctor to continue treatment, or sometimes the court will order that the patient is transferred to another facility if possible. The doctor says, I would do anything to keep this patient alive, but there's nothing I can do now, the patient's suffering. I mean, it's a big decision for the doctor to want to terminate treatment, and the family to want to continue the treatment. So we do have those disputes, even with or without an advance directive. We have disputes, and even though I say that these are enforceable advance directives in the United States, honestly, if there's going to be a dispute, usually one side or the other will go to the court to try to get a court order to have someone else make that final decision about the patient's care. Yes.
Magna Carta. I'm working in relocations now, but that has nothing to do with this. I have one specific question. Where do you get those forms? You said that they've been developed in Japan.
Mm-hmm.
They don't have them at 7-Eleven?
Right, they don't have to. I met with a doctor, and she showed me a book that she had written that has just been published. So what I need to do when I get back to the United States, I do have her name in my book. I don't know if I have her. I don't have her card with me. It's where I'm staying, but it was all in Japanese, so I need to write to her to ask her to give me the English translation. It would for me, but I wanted to know. Because I was unable. She showed this to me, but I was unable to write what it was.
Okay, so we've got.
So if
I
could
say that it exists.
Yes, it's just been published. So if I could talk to you later and perhaps get your email address so I can forward you the
And
information.
just as sort of balancing the background, when my mother died, in her apartment, there were between 15 and 20 non-resuscitation orders that had been updated every 6 months and placed in increasingly prominent places. And her consideration was not financial. It was purely, I want to decide. So it's, even in America, it's not always a financial decision. It can be autonomy. On the other side, my in-laws were unable to allow anyone to tell anyone that they had a terminal condition, and I watched 2 of the people die rather messily as a result. So in between there, it'd be nice to know where the forms are.
Yeah. So you're saying that in the United States there was a doctor who would not tell the diagnosis of the patient?
No. In Japan, the doctor would not tell the patient, and the family would not allow anyone to discuss it or tell the patient. And that was all in Japan on one extreme. On the other extreme, you had, I will determine the time.
So as I said, it is developing more patients want to know, and more doctors are actually telling patients. But there are still those doctors who will not tell patients, and I've been told that it's more likely to happen in the big cities, that doctors will give the terminal diagnosis to a patient.
There seems to be some confusion between making a diagnosis and actually causing the condition. He didn't have cancer until you said he got cancer.
Oh, okay.
So you caused it. Yeah.
It's putting things into words.
Yeah. And it doesn't exist until somebody says it, so don't say it so it doesn't happen. But it does. I'll do volunteers.
May my name is Peggy Kanada, and like Meg, I am married into Japanese society, but in America. And I believe this lovely doctor spoke to the problem of getting all the relatives to agree. And I think this is a very, I mean, despite the fact that there are fewer and fewer children, siblings disagreeing, it seems to be not so easy to get spouse, brothers and sisters, children to come together and talk about these issues, let alone for the person themselves to sort of want to think about it. I believe that one of the big things in medical care, this do not cause suffering, do not hasten a person's death, is part of the feeling of not telling the patient, the person involved, that they do have a terminal illness. That by not putting things into words, you aren't burdening that person with this overwhelming problem and actually hastening their death because they'll give up, or they'll be so frightened or whatever it is. So, I mean, what is compassion? What is preventing suffering? There are lots of ins and outs, but it would be nice if I could write something in English as an American and get my Japanese extended family to agree to it, and find a doctor who would deign to read it. It's something as an expat. But for example, just this problem of forms, I sort of have talked to a lawyer in the States, and they say, well, where are you located? I'll give you a directive for whatever state it is, but I don't have an address in the States at this point. There are a lot of long-term expats. I think there are a lot more international marriages, obviously. I think we need some international laws, perhaps.
International law is a whole
another
area, but in terms of what is available here, because you fill form in one state and in the United States and then move here, that form's not enforceable here.
Right.
And as long as there's no law, right, there's only the guidelines saying this is how the doctors make decisions regarding terminal care, there will be these continuing issues. Yeah, I don't feel like I can come and say, well, there needs to be a law. I think that people here need to make that type of decision about what's best. So in terms of a society where more decisions are going to be made by families, the reality is that there will be family disputes. And in a futility dispute, no one wants to be that one person who goes against everyone else and says, let's just pull the plug, it's really the best thing for our relative. Right? There might be other people who agree, but who won't say anything. And the reality is here, there's no law ranking people about who to look to first if a decision needs to be made and there's no advance directive. In some jurisdictions in the United States, it's actually an order, so spouse will be first. And there's certainly a lot of litigation when the spouse and family members who are not at that level of decision-making power have a dispute. So we do see that. But where we have just a general family decision-making process under these guidelines in Japan, these disputes do arise. And it does give a lot of power to if there's one person who says, I disagree with everybody else. Yes.
very specific question. I actually have a friend who's currently suffering ALS, delayed sclerosis.
I know it's commonly Ley's disease.
The illness of the promoter. So,
Yes, it's hard to hear. So, her concern, I mean, she has a case that is advancing very quickly. And her concern is that I think many of the people with ALS, they often retain the eye movement, so they can express themselves and using their eyes. But there are cases that you lose that as well. In which case, there's no way of communicating. So, for fear of that, currently she's choosing not to be put on life support, especially the respiratory. Some of the time they can have operations.
Like an intubation? I'm not sure.
Not just the oxygen mask, but I mean more than
A breathing tube, so something to help her to breathe.
if you kind of
It's
you have surgery.
right, and it breathes for it
So
helps.
because I mean if you have that, I mean I wonder whether I guess I mean if you can express that you want that to be taken out,
Oh,
they can. I'm not sure. I wonder. Maybe
once
you have that,
intubation is done, it's
you
very
have to be able to take it off yourself. Right?
it's very difficult to get that undone. So that's why something like the do not resuscitate provision that's available
So
in
you
the
have to
uniform
choose
law.
not to have that surgery, I guess.
Yes, you have to choose. You have to. One would have to make that statement, and that do not resuscitate portion of the uniform law would need to be law in a particular jurisdiction, because it's not going to be available in every state in the United States. Also, though,
Out in Japan.
right, non-Japan is no enforceable advance directive, but another issue that comes up in regard to any type of care is that if that form's not available, or at the time someone is giving treatment to a patient, or if there's the emergency medical service goes to a person's house and intubation is necessary, emergency care is given. And so once there's intubation, it's very difficult to withdraw that.
ALS, I mean, is a very specific illness.
Yes.
I wonder whether you encounter cases, actual cases.
Oh.
Or, maybe not together, but
in terms of the case law, yes, there are cases involving.
because I mean,
Yes.
you feel pain, you feel
Yes.
discomfort, but you cannot express something. It
Yes.
can happen, but you cannot express anything.
Yes.
So I wonder what happens in these cases.
Well, in Japan, since there's no law in regard to advance directives, what one would hope is that your friend would have these discussions while she's able to communicate about what treatment she wants, and that she's able to find a provider who's willing to follow the directions.
So that's the only way is to decide things before you lose your communication.
I'm not sure, I don't know how else it would be able to be done afterwards. Because even if she were to complete something like a healthcare proxy, so she chooses someone else, that person should decide according to what she would want. And certainly, I think for certain situations, or many situations, that proxy would go. Right? But there might come some situation that was sort of not discussed.
But for example, I mean, in real terms, I mean, if she once she loses her eyesight, for example, she wants the respiratory medical support to be taken out. Can anybody do that?
No, it won't be taken out, but most likely, right? If she's still living, it's not considered a fetal situation. I think it would be very difficult for anyone to have that taken off. Yes.
I'm Annie, repetition undergraduate from Louisiana.
Do you want the microphone? Is it okay?
Well, I think I can project. If confidentiality permits, could you tell us about an interesting case your clinic handled? A specific one.
A specific one? In regard to,
Well, where there was a disagreement or something.
I'd have to think about what I would be able to say.
I mean, it just sounds like it is, as you have outlined, a real minefield. Just
It is.
wondering how, actually on the ground, these things get worked out.
Oh, yeah, I don't think I know enough specifics to be able to tell you. Because I have not been in the hospital at the time where these forms have had to be enforceable. So I don't know the specifics. I've helped patients or clients, where my students have helped clients
To complete the
These
system.
yes. So I believe these forms have been used for our clients. But I can't give you specifics about any disagreements which occurred with these
Yeah,
forms.
well, I'm fortunate that neither of my parents had these directives, but it didn't come down to that. But I felt that when my father was dying, that the doctors kept wanting to do more things to him. And, I said, we're stopping. We're stopping right here, and we're going to wait a few days. And he died the next day. And they wanted to, do all sorts of things that would have been incredibly painful, in my opinion.
And this was in the United States?
Yes. But he did not have any directives.
Well, I do know one situation. We didn't help the patient to complete this form, but patient completed an advance directive naming his wife, his second wife, is the power of attorney. And then he became incapacitated. The doctor wanted to continue with a form of treatment that his children, which were the stepchildren to the wife, right? So the children wanted to follow the doctor, and the wife was waving around the advance directive saying, I have the power of attorney, so we're turning this off. We're not continuing. He doesn't want it to continue. And so the children, they saw that the wife had been selected and she had the power of attorney, but they were really suspicious of her. And they didn't really believe that she was working in the father's best interest. And so the children convinced the wife, and the doctor followed what he wanted to do, which was to give the treatment, and some treatment was given. The father eventually died, but he was given some more treatment, and the children were satisfied. They really believed that he would have wanted the treatment that was given, despite the fact that he had chosen his wife as the person that had the power of attorney. So that there is one situation. So the advance directive wasn't really followed, right, in a sense. Yes?
My name is Ito, working at Meiji Jingu, Shinto Shrine. So you mentioned about the religious aspects. And could you elaborate on what elements of religious aspects influence on life decision making? And if possible, could you, what else do you think is a major characteristic different between Americans and Japanese American and Japanese in Japan because the decision making for it.
I'm coming in, once you said where you worked, I thought maybe you would be able to help me with this. You can discuss this. In terms of, think about, do we talk, is death just a natural part of life?
Right.
Right, so in religion, death is a natural part of life. So we should be able just to go down the path, and when it comes, right? But what's interesting looking at this, even from the religious aspect, is if we think that, well, this is God's decision, so it's time to die. So let's not continue any treatment. There's just one.
In
Pardon?
Japan,
I would say that some religions follow this. So I guess I wouldn't say that all Japanese in Japan follow this. In fact, there was a study of some people in South Asia looking at this. So thought is that if the religious thought is death is it's a natural part of life, it's a step in this process. So we shouldn't continue with any extreme measures if someone is dying. We should let the body take its course. But there are others who have the same religious beliefs that it's part of the natural path. Let's say medical science has advanced to the point where there is something that can be done to continue the life a little bit longer. So actually, our religion dictates that we give more medical care.
Do everything possible.
Because it can be given, and our religious purposes are served if we do give patients more care. So I can't give you any sort of pinpoint to any religion in terms of this aspect of when it's time to go, let's just follow this natural path. Except to say that there are religions, including the Buddhist religion, which thinks about this natural path, and the discussion of death is something that is okay to talk about in life, right? So it's not a taboo subject. But when we think about making advanced plans and actually committing thoughts to paper and thinking about specific conditions of the body, it becomes more difficult to have these discussions.
May I just ask if perhaps it's a Shinto way of thinking about things, and I use that as a very broad term, but I'm a mother of 2 children, and as they were growing up, I had a deep conviction deep inside me that if my child should be killed in an accident, that if they could be of use by donating an organ, not the whole body, but maybe even just the corneas of their eyes, that this would be a way to feel as though their lives had been worth something. As a mother, I would want to do that kind of thing. But my Japanese husband, the minute I would broach this, talking about what might happen, the sanctity of the human body, the beauty of a full body should never be interfered with. And he and my Japanese relatives were appalled that I would ever think about this, of cutting up something that had, in a sense, come, maybe not from God, but was by nature perfect and complete. And I wondered, it isn't very Buddhist, but I think perhaps it's that kind of thinking comes.
Yeah, I think your talk is more close to Buddhism idea.
Not Shinto.
Actually, Shinto is not clearly mentioning about that issue yet. So, not yet. And probably in the future as well. But personally, I do not disagree with providing organs to make use of these organs. Shinto is not saying about it.
I very appreciate your way of thinking. I myself am carrying the organ donation card with me. I think I want my body to be donated to the person who needs a part of my body. Because I know as a doctor how many patients are waiting desperately for kidney, the people who are under dialysis, and how so many people are dying to have cornea, the blind people. So I appreciate the way of thinking that many people are agreed to donate a part of the body to be a help of the person who are left behind.
And growing numbers, I think, in Japan. Is it a majority now, do you think?
I don't think so.
No, I think it's still a minority.
May I just put one comment? What was this? Okay. I think it's a Japanese culture to see the entire body, seeing out. That's part of the culture. So donation of any organ is not, I believe, a part of our culture. That's a dignity, whatever, and we have a lot of Japanese phrases to talk about the death, like a Tenjo Mantosu. Die at the age the God decide, regardless about when he died or she died. So anybody like the 68 Tenjo Mantosu. That's a way how to see the reality of the death, and then very neutralize the situation. We can participate in the funeral without crying. That way. And I have a brother living in Iwate where lots of victims are born. He frequently visited the sites and saw the crucial momentums every day, but people getting very calm to think about the death, excluding kids. Kids are extremely difficult, he found. But age above 20, they could see and settle down stage quickly happened in 10 days. That amazed him a lot. That's a part of our culture. So we are very neutral about the death, I believe. We are rather worried about the future, like myself, when I can die. 85 or 90, and doctor stop my being dead. That's my worry. I don't die when I want to die. So Navajo type, I like.
When there are some studies of Japanese in Japan about having discussions, a number of them said, when it's time to go, I just want to go. I just want it to happen.
Do not resuscitate.
There are temples where you can get ovulants for Pokuri.
Yeah, so that is their hope, right? So it happens suddenly, and that's it. So one doesn't have to make any plans, because it's just going to happen.
Actually, my mother visited that temple.
I think there are more people in Japan who are like that, and I have friends, parents, who, when they were in their critical situation, they stopped doctors putting life support. For example, for organ donation, of course, I mean, you have to think the body might not be in the Japanese culture. But I'm a bit concerned, I'm sort of a bit indecisive myself, and I'm concerned because I think it's at the time when the brain is dead that they have to decide whether the organs will be donated. And I have still some questions about that. So there are two separate issues.
There's a lot of discussion and conflict about organ donation in terms of trying to, they call it harvest, right? Trying to harvest the organs when they're still usable, but when is the best time to do that? Because there's a body, right? And it's still breathing, or even if it's artificially breathing. So that's why the harvesting team is not the same team as the treatment team for that patient. So they've got to make sure that what is being done is good for the patient who has not been declared dead. Right? So while we still have someone who's alive, though, someone is going to have discussion with the family members about organ donation. And it's a very difficult area, and there are difficult discussions among the hospital staff, the providers, about how to best go about serving the patient, right, and also getting the organs donated.
I think we only need one last question, or?
Well, I'd like to thank you, Professor Suzuki. Thank you very much. Wrote some copies of this Uniform Healthcare Decision Act. So we can take this and there'll be an exam at the next session.